Hello at magandang gabi sa inyo. Itong si Lolo Ray. Okay? Para tapusin na ang aking pagbabasa para sa ating mga kababayang katulad ko na ordinaryong mamamayan na konti lamang ang kaalaman sa batas. Nais ko na namang basahin ang nalalabi sa civil procedure. Okay? Ito pa rin po ang inyong programa kung saan binabasa ko ang mga batas at sinusubukan ko ipaliwanag in layman's terms. Okay? Okay, magpunta na tayo. Civil Procedure Rule 61, Support Pendente Lite. Sabi rito, Section 1, Application. At the commencement of the proper action of proceeding, or at any time prior to the judgment or final order, a verified application for support pendente lite may be filed by any party stating the grounds for the claim and the financial conditions of both parties and accompanied by affidavits, depositions, or other authentic documents. Ngayon, ang maganda nito, tinutukoy niya yung support pendente lite. Ano ba ito? Di ba? Madaling maunawaan yung support pero yung may pendente lite. Hindi ko alam. Alamin natin. Okay, Google natin. Support pendente lite. Ayan. Sabi rito. Ano ba yan? Ano ba yan? Ganda sana yung pag ginugol mo, andun na agad no? Pero, okay. Asa na? Ito. Ang ibig lang yata sabihin nun ay support pending litigation. Yun lang yata ang ibig niya sabihin. Okay, nangihingi ka ng support habang merong nililitis. Okay? Tignan pa natin. Magtingin pa tayo ng ibang very simple lamang na na kahulugan. Sabi rito, while the case is pending. Okay? Sige, balik na tayo doon sa binabasa natin na rules of court. Okay. Support pendente lite. Nangihingi ka ng support while the case is pending. Okay. Section 2. Comment. Sabi niya rito. A copy of the application and all supporting documents shall be served upon the adverse party. Siyempre, kailangan binibigyan mo lagi ng notice ng copy ng iyong mga supporting documents. Yung kalaban mo, who shall have 5 days to comment thereon unless a different period is fixed by the court upon his motion. The comments shall be verified and shall be accompanied by affidavits, depositions, or other authentic documents in support thereof. Section 3, Hearing. After the comment is filed or after the expiration of the period for its filing, the application shall be set for hearing. So, ano pala? Hinihiring pala. Dinidinig pala. Itong support pendente lite. So, the application shall be set for hearing not more than 3 days thereafter. The facts in issue shall be proved in the same manner as is provided for evidence on motions. O yung pamamaraan doon ng pag... yung the facts in issue shall be proved. Papatunayan mo yun sa parehong pamamaraan sa kung paano mo binibigyan ng sa paraang kung paano mo sinusuportahan ang kung ikaw ay nag-file ng isang motion. Section 4, Order. The court shall determine provisionally the pertinent facts and shall render such orders as justice and equity may require, having the regard to the probable outcome of the case and such other circumstances as may aid in the proper resolution of the question involved. Period. If the application is granted, the court shall fix the amount of money to be provisionally paid or such other forms of support as should be provided, taking into account the necessities of the applicant and the resources or means of the adverse party and the terms of payment or mode for providing the support. If the application is denied, the principal case shall be tried and decided as early as possible. Section 5. Enforcement of order. If the adverse party fails to comply with an order granting support pendente lite, the court shall motu proprio or upon motion issue an order of execution against him without prejudice to his liability for contempt. Kapag daw ang isang tao, when the person ordered to give support, inutusan siyang magbigay ng support pendente lite, refuses or fails to do so, any third person who furnished that support to the applicant may, after due notice and hearing in the same case, obtain a writ of execution to enforce his right of reimbursement against the person ordered to provide such support. Section 6. Support in criminal cases. In criminal actions daw where the civil liability includes support for the offspring as a consequence of the crime and the civil aspect thereof has not been waived, reserved, and instituted prior to his filing, yung akusado raw, the accused, may be ordered to provide support pendente lite to the child born to the offended party allegedly because of the crime. The application therefore may be filed successively by the offended party, her parents, grandparents, or guardian, and the state in the corresponding criminal case during its pendency in accordance with the procedure established under this rule. So siguro, maganda example dito yung isang rapist, nanggasa siya, nabuntis niya. So habang nililitis yung kaso niya for rape, pwede siyang filean ng support pendente lite para dun sa batang isinilang dahil as a consequence ng kanyang krimen na ginawa. Section 7. Restitution. When the judgment or final order of the court finds that the person who has been providing support pendente lite is not liable, therefore, it shall order the recipient thereof to return to the former. Isusoli daw doon sa akusado na napatunayan na wala namang sala, the amounts already paid with legal interest from the dates of actual payment without prejudice to the right of the recipient to obtain reimbursement in a separate action from the person legally obliged to give the support. Should the recipient fail to reimburse said amounts, the person who provided the same may likewise. So kunwari may nakasuhan ng rape, nakabuntis siya, sinabi ng korte, suportahan mo yung bata habang dinidinig yung kaso mong rape. Bandang huli, napatunayan, hindi naman siya ng rape. Hindi naman siya ang tatay nung batang isinilang as a consequence of rape. Pwede raw, sasabihin daw ng korte na doon sa recipient na soli mo yung binigay niya kasi hindi naman siya yung dapat na magbigay ng support dyan sa batang yan. Kung hindi naman daw maibalik, pwede mag-claim yung akusado na napatunayan wala namang sala, mag-claim siya doon sa rapist. Dito sa example natin na yung rapist na nakabuo dun sa batang kailangan bigyan ng support. Punta tayo sa special civil actions. Rule 62, interpleader. Ito raw yung mga special civil actions. What's so special about you? Section 1, when interpleader proper. Whenever conflicting claims upon the same subject matter are or may be made against a person who claims no interest whatever in the subject matter or an interest which in whole or in part is not disputed by the claimants, he may bring an action against the conflicting claimants to compel them to interplead and litigate their several claims among themselves. Okay? So, ganun pala yun, no? Pag may conflicting claims, iisa lamang ang subject matter are or may be made against a person who claims no interest whatever in the subject matter, he may bring an action against the conflicting claimants to compel them to interplead. Kayo ang mag-litigate among yourselves. Yun ang sabi rito. Section 2, order. Upon the filing of the complaint, the court shall issue an order. Mag-i-issue ang korte ng order requiring the conflicting claimants to interplead with one another. Hoy, tingin namin kailangan yung magdinggin nyo with one another ito. Maglalabas siya ng order. If the interests of justice so require, the court may direct in such order that the subject matter be paid or delivered to the court. Dali nyo na nga yan dito, yung pinag-aawayan nyo. Ganon. Pinag-aawayan nyo yung babae, dali nyo dito. Charot. Section 3, Summons. Summons shall be served upon the conflicting claimants together with a copy of the complaint and order. Section motion to dismiss. Within the time for filing an answer, each claimant may file a motion to dismiss. Para lang daw to sa interpleader ha. Motion to dismiss on the ground of impropriety of the interpleader action or another appropriate ground specified in Rule 16. The period to file the answer shall be told, and if the motion is denied, the movant may file his answer within the remaining period, but which shall not be less than 5 days in any event, reckoned from notice of denial. Section 5. Answer and other pleadings. Each claimant shall file his answer setting forth his claim within 15 days from service of the summons upon him, serving a copy thereof upon each other of the other conflicting claimants who may file their reply thereto as provided by these rules. If any claimant fails to plead within the time herein fixed, the court may, on motion, declare him in default and thereafter render judgment barring him from any claim in respect to the subject matter. And responsive pleadings thereto as provided by these rules. Section 6, Determination. After the pleadings daw, nagsumiti na ng mga pleadings of the conflicting claimants have been filed and pre-trial has been conducted in accordance with these rules. Na-discuss na natin yung pre-trial na yan. The court shall proceed to determine their respective rights and adjudicate their several claims. Desisyonan na natin yung mga claims ninyo. Section 7, Docket and other lawful fees, costs, and litigation expenses as liens. Liens, ibig sabihin ng claims. The docket and other lawful fees paid by the party who filed a complaint under this rule, as well as yung costs daw ng litigation expenses, shall constitute a claim or a lien or change upon the subject matter of the action unless the court shall order otherwise. Rule 63, Declaratory Relief and Similar Remedies. Ito yung mga iba-ibang mga remedyo na pinoprovide ng special remedies. Ano ba sinabi ko kanina? Special civil actions. Declaratory relief naman. Rule 63, sabi rito, Section 1. Who may file a petition for declaratory relief? Any person daw interested under a deed, will, contract, or other written instrument or whose rights are affected by a statute or law or executive order o isang regulasyon, ordinansa, or any other governmental regulation may, before breach of violation thereof, bring an action in the appropriate regional trial court to determine any question of construction or validity arising and for a declaration of his rights or duties thereunder. An action daw for the reformation of an instrument, yan, to quiet title to real property or remove clouds therefrom, or to consolidate ownership under Article 1607 of the Civil Code may be brought under this rule. So, pwede ka mag-motion for quieting of the title kung merong kaguluhan sa iyong title and for declaratory relief. Section 2, Parties. Sino yung mga partidos? All persons who have and no declaration shall, except as otherwise provided in these rules, prejudice the rights of persons not parties to the action. So sabi rito, hindi natin pwedeng i-prejudice ng mga taong hindi naman partido sa action na ito. Section note on Solicitor General. May friend ako dyan na abogado. Si Attorney Miles. Ino-notice na naman yung opisina nila. In any action, ino-notify yung opisina nila. Mahina ang internet. Na kailangan natin magpatay ng device. Okay, patay muna tayo ng ibang device para tayo naghahang. Sabi dito, in any action which involves the validity of a statute, executive order or regulation or any other governmental regulation, yun daw Solicitor General shall be notified by the party assailing the same and shall be entitled to be heard upon such question. So yung Office of the Solicitor General yan, magpapadala siguro sila ng abogado galing sa kanila, special prosecution, as special prosecutor under the Solgen's office, or i-empower nila siguro yung prosecutor sa yung city or municipality para dinggin ito in favor of the government. Section 4, Local Government Ordinances. In any action involving the validity of a local government ordinance, the corresponding prosecutor or attorney of the local government unit involved shall be similarly notified and entitled to be heard if such ordinance is alleged to be unconstitutional. The Solicitor General shall also be notified and entitled to be heard. Bakit ba nino-notify ang Solicitor General? Alam natin sa Maynila ang opisina. It's because ang Solicitor General ang primary law office ng gobyerno. Yan ha. Section 5, Court Action Discretionary. Except in actions falling under the second paragraph of Section 1 of this rule, the court, motu proprio or upon motion, lagi sinasabi yun, no? Motu proprio by the court's own initiative, or upon a motion, magmo-motion yung abogado, yung counsel ng isang partido, may refuse to exercise the power to declare rights and to construe instruments in any case where a decision would not terminate the uncertainty or controversy which gave rise to the action, or in any case where the declaration or construction is not necessary and proper under the circumstances. Section 6, Conversion into ordinary action. If before the final termination of the case, a breach or violation of an instrument or a statute, executive order or regulation, ordinance, or any other governmental regulation should take place, the action may thereupon be converted into an ordinary action, and the parties shall be allowed to file such pleadings as may be necessary or proper. Rule 64. Review of judgments and final orders or resolutions of the Commission on Elections and Commission on Audit. Tignan natin. Sinasabi rito, kung hindi ako nagkakamali, yung review, parang ang magre-review nito, Court of Appeals ba o Supreme? Basahin na lang natin, nalimutan ko na yun. Ano ba yung scope nito? This rule shall govern the review of judgments and final orders on resolutions, final orders or resolutions of the COMELEC and Commission on Audit. Ito raw yung marami. Kumbaga, in a layman's term, apila ka dun sa naging desisyon ng mga ahensyang nabanggit, COA and COMELEC. Sabi rito, a judgment or final by the party to the Supreme Court, tama nga ako, CA, on certiorari under Rule 65 except as herein after provided. Mamaya pupunta tayo sa ipaliliwanag natin yung certiorari under Rule 65. Kasi dati may nabasa na tayo certiorari under Rule 45. That is a mode of appeal. Technically speaking po, sa mga nag-aaral ng batas, hindi yata appeal itong Rule 65 na to, kundi it is a special civil action. Pero in layman's term, parang umapila ka na rin. Parang gano'n. Okay. Section 3. Time to file petition. The petition shall be filed within 30 days from notice of the judgment or final order or resolution sought to be reviewed. The filing of a motion for new trial or reconsideration of said judgment or final order or resolution, if allowed under the procedural rules of the commission concerned, shall interrupt the period herein fixed. If the motion is denied, the aggrieved party may file the petition within the remaining period, but which shall not be less than 5 days in any event reckoned from notice of denial. Section 4. Upon the filing of petition, the petitioner shall pay to the clerk of court the docket and other lawful fees and deposit the amount of 500 pesos for costs. Siguro it is possible na mas mataas na ito sa ngayon. Excuse me lang po. Wait lang. Okay, tayo nagbabalik. Section 5, Form and Contents of Petition. The petition thou shall be verified and filed in 18. Pag Supreme Court, parang 18 na yata lahat, ano? Pag Court of Appeals, sinasabi 7 legible copies. Pag Supreme Court, kung napapansin nyo, 18 legible copies. The petition shall name the aggrieved party as petitioner, kumbaga yung umaapila, yung natalong party, as petitioner, and shall join as respondents the commission concerned and the persons or persons interested in staying the judgment. Isasama daw yung komisyon at yung mga taong interesado ron sa na mapanatili yung judgment at hindi mabaliktad. Final order or resolution akuo. The petition shall state the facts with certainty, present clearly the issues involved, set forth the grounds in brief arguments relied upon for review, and pray for judgment annulling or modifying the questioned judgment, final order, or resolution. Findings of fact of the commission supported by substantial evidence shall be final and non-reviewable. So yung mga findings daw nung komisyon, pare nag-aapila ka, pero yung meron na siyang findings of fact na sinusuportahan ng substantial evidence shall be final at hindi na raw reviewable. Substantial evidence. The petition shall be accompanied by a clearly legible, duplicate original or certified true copy of the judgment, final order, or resolution subject thereof, together with certified true copies of such material portions of the record as are referred to therein and other documents relevant and pertinent thereto. The requisite number of copies of the petition shall contain plain copies of all documents attached to the original copy of said petition. The petition shall state the specific material dates showing that it was filed within the period fixed herein and shall contain a sworn certification against forum shopping as provided in third paragraph of Section 3 Rule 46. Parang kung napapansin ko, parang lahat yata ng mga kaso dapat mayroong naka-attach na certification of non-forum shopping. The petition shall further be accompanied by proof of service of a copy thereof on the commission concerned and on the adverse party, and of the timely payment of docket and other lawful fees. Yun daw, failure ng petitioner to comply with any of the foregoing requirements shall be sufficient for the dismissal of petition. So, kailangan mag-comply ka sa lahat ng nakasaad dito. Otherwise, magiging sapat na yun para i-dismiss nila ang iyong petisyon. Dismiss ng korte ang iyong petisyon. Section 6, Order to Comment. If the Supreme Court, the highest court of the land, finds the petition sufficient in form, sapat ang form and substance, it shall order the respondents to file their comments on the petition within 10 days from notice thereof. Otherwise, the court may dismiss the petition outright. The court may also dismiss the petition if it was filed manifestly for delay or the questions raised are too unsubstantial to warrant further proceedings. Section 7. Comments of Respondents. The comments of the respondents shall be filed in 18 legible copies. Ganun din. Kanina, 18 legible copies yung, kumbaga, yung reklamo, yung apila ng petitioner, yung respondent, 18 din na ipapasa niya. The original shall be accompanied by certified true copies of such material portions of the record as are referred to therein together with other supporting papers. The requisite number of copies of the comments shall contain plain copies of all documents attached to the original, and a copy thereof shall be served on the petitioner. No other pleading may be filed by any party unless required or allowed by court. Malinaw yun unless required or allowed. Section 8. Effect of filing. The filing of a petition for certiorari shall not stay the execution of the judgment or final order or resolution sought to be reviewed, unless the Supreme Court shall direct otherwise upon such terms as it may deem just. Okay, Section 9, Submission for Decision. Unless the court sets the case for oral argument or nag-require siya ng mga partido mag-submit ng memoranda, the case shall be deemed submitted for decision upon the filing of the comments on the petition or of such other pleadings or papers as may be required or allowed or the expiration of the period to do so. So, may period na yon para desisyonan na ng korte ang iyong petisyon. Ito na yung sinasabi nating Certiorari, Prohibition, and Mandamus. Certiorari under Rule 65. So, basahin natin. Ano ba ito? Petition for certiorari. When any tribunal, board, or officer exercising judicial or quasi-judicial functions, yan yung mga example, yung COA, Commission on Audit, desisyon sa COMELEC, has acted, ito daw mga tribunal na ito, or board, officer, exercising judicial or quasi-judicial functions, has acted without or in excess of its jurisdiction or with grave abuse of discretion amounting to lack or excess of jurisdiction. Ito yung pinakamahalagang keywords dyan eh. And there is no appeal. Wala na raw ibang appeal or any plain, speedy at sapat adequate remedy in the ordinary course of law. Yun daw person na aggrieved o na perwisyo rito, yung natalo rito, thereby may file a verified petition in the proper court, alleging the facts with certainty and praying, humihiling siya, that judgment be rendered annulling or modifying the proceedings of such tribunal, board, or officer, and mag-grant sana such incidental reliefs na hinahangad niya as law and justice may require. So, yun po ang petition for certiorari under Rule 65. Ito raw petition na to. This petition shall be accompanied by a certified true copy of the judgment, order, or resolution subject thereof, copies of all pleadings and documents relevant and pertinent thereto, and a sworn certification of non-forum shopping as provided in the third paragraph of Section 3, Rule 46. Punta naman tayo, Petition for Prohibition, Section 2. Tapos na tayo sa Certiorari on Rule 65. Dito naman tayo sa Petition for Prohibition. When the proceedings of any tribunal, corporation, board, officer, or person, whether exercising judicial, quasi-judicial, or ministerial functions, are without or in excess of its or his jurisdiction, or with grave abuse of discretion amounting to lack or excess of jurisdiction, and there is no appeal or any other plain, speedy, and adequate remedy in the ordinary course of law. Parehas din sila halos nung una nating sinabi. Ang isa raw tao na aggrieved thereby may file a verified petition in the proper court, alleging the facts with certainty and praying the judgment be rendered commanding the respondent, utusan mo yung respondent, utusan ng korte yung respondent to desist from further proceedings in the action or matter specified therein, or otherwise granting such incidental reliefs as the law and justice may require. Ganon din siguro to. The petition shall likewise be accompanied by a certified true copy of the judgment, order, or resolution subject thereof, copies of all pleadings and documents relevant and pertinent thereto, and the sworn certification of non-forum shopping as provided in the third paragraph of Section 3, Rule 46. Tungo naman tayo sa Section 3, Petition for Mandamus. Dito na naman kinalaman ng tao rito sa Petition for Mandamus na ito. Sabi rin dito, ganon din siguro yung mga entrada rito. When any tribunal, corporation, board, officer, or person unlawfully neglects, ayun naman, unlawfully neglects the performance of an act, kinalimutan nila o hindi nila ginawa yung dapat nilang gawin, which the law specifically enjoins as a duty resulting from an office. Duty mo yan dahil nandiyan ka sa opisinang yan. O duty mo yan dahil hawak mo yung trust na ito. Or station, or unlawfully excludes another from the use and enjoyment of a right or office to which such other is entitled. O halimbawa niyan, dadaan siya sa condominium, common area niya yung daanan, hindi mo siya pinadaan. Example lang yon, karapatan niya, entitled siya na hindi mo siya pina-enjoy. And there is no other plain, speedy, and adequate remedy in the ordinary course of law. Yun daw tao o the person aggrieved thereby may file a verified petition in the proper court alleging the facts with certainty and praying that judgment be rendered commanding the respondent immediately or at some other time to be specified by the court to do the act required to be done to protect o para mapangalagaan yung mga karapatan at para daw bayaran to pay acts of the respondent. The petition shall also contain a sworn certification of non-forum shopping as provided in the third paragraph of Section 3, Rule 46. Section 4. When and where to file the petition. Saan naman tayo magpa-file ng ganito? The petition shall be filed not later than 60 days from notice of the judgment, order or resolution. Katanggap ka na ng judgment nila, order or resolution. In case a motion for reconsideration or new trial is timely filed, whether such motion is required or not, the petition shall be filed not later than 60 days counted from the notice of the denial of the motion. Kunwari, nag-motion ka for new trial o nag-motion for nag-MR ka, motion for reconsideration ka, na deny. After mo matanggap yung notice of denial, within 60 days, doon ka magpa-file nitong petition na ito. If the petition daw relates to an act or an omission, isang gawa o isang hindi paggawa ng lawful order of a lawful duty, ang ibig sabihin, ulitin natin, if the petition daw relates to an act, isang gawa o isang gawa na hindi ginawa na lawful duty of a municipal trial court or of a corporation exercising jurisdiction over the territorial area as defined by the Supreme Court. So sa RTC raw na may jurisdiction doon sa MTC na may omission, corporation, board, officer, or a person. Even kung MTC, may hindi sila ginawa, yung municipal trial court, pwede ka mag-file nito na trial court na may sakop doon. It may also be filed with the Court of Appeals, pwede rin daw sa CA, or with the Sandigan Bayan, whether or not the same is in aid of the court's appellate jurisdiction. If the petition naman daw involves an act or an omission of a quasi-judicial agency unless otherwise provided by the law or these rules, yun daw petition shall be filed with and be cognizable only by the Court of Appeals. So, kikilalanin lang daw yan only ng Court of Appeals. Kung yung petition involves an act, isang gawa o isang omisyon ng isang quasi-judicial agency. Sa mga election cases naman daw involving an act or omission of a municipal or regional trial court, the petition shall be filed exclusively with the COMELEC. In aid of its appellate jurisdiction. Section 5, Respondents and Costs in certain cases. When the petition filed relates to the acts or omissions of a judge, court, quasi-judicial agency, tribunal, corporation, board, officer, or person. Ayan, ulitin natin. Kapag daw ang petition na final mo relates sa mga kagagawan o sa mga omisyon ng isang huwes, judge, ng korte, ng quasi-judicial agency, tribunal, corporation, board, officer, or person, the petitioner thou shall join as private respondent or respondents with such public respondent or respondents the person or persons interested in sustaining the proceedings in the court. Isang halimbawa niya, kaya pala pag nagbasa ka ng mga kaso minsan, merong ganito-ganito versus judge ganito, di ba? And it shall be the duty of such private respondents to appear and defend, both in his or their own behalf and in behalf of the public respondent or respondents affected by the proceedings, and the costs awarded in such proceedings in favor of the petitioner shall be against the private respondents only, and not against the judge, court, quasi-judicial agency, tribunal, corporation, board, officer, or person impleaded as public respondents or respondents. So, hindi naman sila madadamay. Yung decision na in favor sa plaintiff, kunwari, it shall be only, yung costs shall be shouldered by the respondent, hindi naman dun sa mga ibang inimplead na public respondents. Yung mga nabanggit natin, judge, court, quasi-judicial agency, tribunal, corporation, board, officer, etc. Unless otherwise specifically directed daw by the court where the petition is pending, the public respondents shall not appear in or file an answer or comment to the petition or any pleading therein. Unless otherwise specifically directed daw ng korte, hindi yung public respondents daw shall not file an answer. Kailangan hintayin mong utusan ka ng korte. If the case is elevated to a higher court by either party, the public respondents, tinutukoy lang dito na hindi na nahihintayin mong utusan ka ng korte, yung public respondents, mga nabanggit natin kanina, judge, court, quasi-judicial agency, etc. So if the case daw is elevated to a higher court by either party, the public respondents shall be included therein as nominal parties. However, unless otherwise specifically directed by the court, they shall not appear or participate in the proceedings therein. Section 6. Order to comment. If the petition is sufficient in form and substance to justify such process, the court shall issue an order requiring the respondent or respondents to comment on the petition within 10 days from receipt of a copy thereof. Such order shall be served on the respondents in such manner as the court may direct, together with a copy of the petition and any annexes thereto. In petitions for certiorari before the Supreme Court and the Court of Appeals, the provisions of Section 2, Rule 56 shall be observed. Period yun. Before giving due course thereto, the court may require the respondents to file their comment to and not a motion to dismiss the petition. So comment lang daw, wag ka daw magpa-file ng motion to dismiss the petition sa mga petitions for certiorari before the Supreme Court and Court of Appeals. Thereafter, the court may require the filing of a reply and such other responsive or other pleadings as it may deem necessary and proper. Section 7. Expediting proceedings. Injunctive relief. Yan ang tinatalakay sa Section 7. Yun daw korte in which the petition is filed may issue orders expediting the proceedings, and it may also grant a temporary restraining order or a writ of preliminary injunction for the preservation of the rights of the parties pending such proceedings. The petition shall not interrupt the course of the principal case unless a temporary restraining order or a writ of preliminary injunction has been issued enjoining the public respondent from further proceeding with the case. The public respondent shall proceed with the principal case within 10 days from the filing of a petition for certiorari with the higher court or tribunal, absent a temporary restraining order or a preliminary injunction, or upon its expiration, period. Failure of the public respondent to proceed with the principal case may be a ground for an administrative charge. So, kailangan yung public respondent, yung mga nabanggit natin kanina, judge, board, corporations, mag-proceed sila with the principal case. Dahil kung di daw, failure thereof may be a ground for an administrative charge. Section 8. Proceedings after comment is filed. After the comment or other pleadings required by the court are filed, or the time for the filing thereof has expired, the court may hear the case or require the parties to submit memoranda. If after such hearing or filing of memoranda or upon the expiration of the period of filing, period for filing, the court finds that the allegations of the petition are true, it shall render judgment for such relief to which the petitioner is entitled. Yun nga lamang daw. However, the court may dismiss the petition if it finds the same patently without merit or prosecuted manifestly for delay, or if the questions raised therein are too unsubstantial to require consideration. In such event, the court may award in favor of the respondent treble costs solidary against the petitioner and counsel, in addition to subjecting counsel to administrative sanctions under Rules 139 and 139-B of the Rules of Res ipsa loquitur. Ibig sabihin ng res ipsa loquitur, the thing speaks for itself. Yung ayan na, obvious na. Yun. So the court may impose motu proprio based on res ipsa loquitur other disciplinary sanctions or measures on erring lawyers, mga nagkakamaling lawyers, for patently dilatory or and unmeritorious petitions for certiorari. Oh, ha? Paparusahan yung mga abogado na umeepal lamang yung mga petition nila for certiorari is unmeritorious. Section 9. Service and enforcement of order or judgment. A certified copy of the judgment rendered in accordance with the last preceding section shall be served upon the court, quasi-judicial agency, tribunal, corporation, board, officer, or person concerned in such manner as the court may direct, and disobedience thereto shall be punished as contempt. An execution may issue for any damages or costs awarded in accordance with Section 1 of Rule 39. Punta naman tayo sa Rule 66, Quo Warranto. Itong Quo Warranto po na ito, yung ikinaso ni Attorney Larry Gadon laban sa dating Chief Justice Lourdes Sereno, na presidential appointee ng nagdaang administrasyon ni Pangulong Pinoy. Okay? Ito yung Quo Warranto. Paliwanag natin. Section 1. Action by government against individuals. So, an action for the usurpation of a public office, position, or franchise may be commenced by a verified petition brought in the name of the Republic of the Philippines against a person who usurps, nagpapanggap, intrudes into, or unlawfully holds or exercise a public office, position, or franchise. Yung mga umuupo dyan na hindi naman kwalipikado. Letter B. A public officer who does or suffers an act which, by the provision of law, constitutes a ground for the forfeiture of his office. Letter C. An association which acts as a corporation within the Philippines without being legally incorporated or without lawful authority so to act. Yun daw yan. Kaya kung mapapansin ninyo, tandem lagi si Attorney Larry Gadon at ang Solicitor General. Kasi yung gobyerno ang nagkakaso rito. Kinakasuhan yung mga ibang members ng government o ng korporasyon daw na hindi naman legally incorporated. Wala naman silang karapatan. Okay? Section 2. When Solicitor General or Public Prosecutor must commence action. The Solicitor General or a Public Prosecutor, when directed by the President of the Philippines, or when upon complaint or otherwise, he has a good reason to believe that any case specified in the preceding section can be established by proof, must commence such an action. No? So, si Solgen Calida, pwedeng inuutos ng Pangulo, gawin mo yan, or sa kanyang sariling palagay, dapat niyang i-commence yung action. Solgen to. Section 3, when Solicitor General or Public Prosecutor may commence action with permission of court. The Solicitor General daw or a Public Prosecutor may, with the permission of the court in which the action is to be commenced, bring such an action at the request and upon the relation of another person. But in such case, the officer bringing it may first require an indemnity for the expenses and costs of the action in an amount approved by and to be deposited in the court by the person at whose request and upon whose relation the same is brought. Section 4. When hearing had on application for permission to commence action. Upon application for permission to commence such action in accordance with the next preceding section, the court shall direct that notice be given to the respondent so that he or she may be heard in opposition thereto, and if permission is granted, the court shall issue an order to that effect, copies of which shall be served on all interested parties, and the petition shall then be filed within the period ordered by the court. Section 5. When an individual may commence such action. A person daw claiming to be entitled. Kunwari si dating Supreme Court Chief Justice Maria Lourdes Sereno, entitled raw siya kunwari. When a person claiming to be entitled to a public office or position usurped or unlawfully held or exercised by another, may bring an action therefore in his own name. Section 6. Parties and contents of petition against usurpation. When the action is against a person for usurping a public office, position, or franchise, the petition shall set forth the name of the person who claimed to be entitled thereto, if any, with an averment of his right to the same, and that the respondent is unlawfully in possession thereof. So yun yun, nagpalagay ng yung mga petisyon laban kay Chief Justice Sereno, isinaad nila doon kung bakit hindi siya karapat-dapat bilang maging punong maestrado ng Korte Suprema. All persons who claim to be entitled raw to the public office, position, or franchise may be made parties, and their respective rights to such public office, position, or franchise determined in the same action. O saan naman ang venue nito? Section 7. Ang action daw under the preceding sections can be brought only sa Supreme Court. Kaya kung mapapansin nyo, kung nanonood kayo ng balita, si Larry Gadon ay nagpunta sa Supreme Court. At rin daw ito sa Court of Appeals or in Regional Trial Court exercising jurisdiction over the territorial area where the respondent or any of the respondent resides. Pero daw, kung ang nagsimula ng action na ito ay ang Solicitor General, it may be brought in a regional trial court in the city of Manila, Court of Appeals, or Supreme Court. Yan kung Solgen ang nagsimula ng action na ito. Okay. Sigurado yung friend ko dyan, palagi sa mga RTC ng Manila, Court of Appeals, at ng Supreme Court. Section 8. Period for pleadings and proceedings may be reduced. Action given precedence. The court may reduce the period provided by this for filing pleadings and for all other proceedings in the action in order to secure the most expeditious determination of the matters involved therein, consistent with the rights of the parties. Such action may be given precedence over any other civil matter pending in court. Ayan Section 9. Judgment where usurpation found. When the respondent is found guilty of usurping into, intruding into, or unlawfully holding or exercising a public office, position, or franchise, judgment shall be rendered that such respondent be ousted, patatasigin siya sa pwesto, and altogether excluded, therefore hindi na siya isasama, and that the petitioner or relator, as the case may be, recover his costs. Such further judgment may be rendered determining the respective rights in and to the public office, position, or franchise of all the parties to the action as justice requires. Magtungo tayo sa Section 10. Ito daw yung rights of persons adjudged entitled to public office, delivery of books and papers at damages. Yun ang pag-uusapan sa Section 10. So, if judgment be rendered in favor of the person averred in the complaint, o yung nireklamo ko kunwari na wala siyang karapatan para sa pwesto na yan, siya yung nanalo, he take upon himself the execution of the office and may immediately thereafter demand of the respondent. Magde-demand siya sa akin all the books and papers in the respondent's custody or control appertaining to the office to which the judgment relates. if the respondent refuses or neglects contempt as having disobeyed the lawful order of the court. So, kailangan basta inorderan ka ng korte, sundin mo. The person adjudged entitled to the office may also bring action against respondent to recover the damages sustained by such person by reason of usurpation. So, kunwari, doon sa example natin kanina, si Atty. Larry Gadon. Kunwari lang, in-example ko na lang siya. Kasi kilala ninyo. Napatunayan na nanggugulo lang siya, walang merito ang kanyang co-waranto laban kay Justice Sereno. Kunwari, gano'n na nangyari. Pwede daw ma-recover yung damages sustained by such person by reason of usurpation. Mali pala ako ng example. Ang sabi rito, yung respondent ay hindi na siya entitled talaga sa posisyon. Kunwari sa example nga natin, si Chief Justice Sereno, hindi siya entitled. Yung dapat na entitled daw, yung isinapawan niya ng pwesto, may also bring action against kay Chief Justice Sereno to recover the damages sustained by such person by reason of usurpation. Sinapawan mo ko pero hindi ka naman pala karapat-dapat dyan. May action ako sa'yo for damages. Yun ang tunay na ibig sabihin pala nung huling linya na yun. Okay? Section 11, Limitations. Nothing contained in this rule shall be construed to authorize an action against a public officer or employee for his ouster from office unless the same be commenced within 1 year after the cause of such ouster or the right of the petition to hold such office or position arose, nor to authorize an action for damages in accordance with the provisions of the next preceding section unless the same be commenced within 1 year after the entry of the judgment establishing the petitioner's right to the office in question. Section 12, Judgment for Costs. In an action brought in accordance with the provisions of this rule, the court may render judgment for costs against either the petitioner, the relator, or the respondent, or the person or persons claiming to be a corporation, or may apportion the costs as justice requires. So, break lang tayo. Pupunta na ako sa Rule 67. Tapusin na natin to. Yung buong civil procedure, tapusin na natin. 67 to 71 na lang tayo. Okay, ako yung muling nagbabalik para sa Rule 67, Expropriation. Section 1. The complaint. The right of eminent domain shall be exercised by the filing of a verified complaint which shall state with certainty the right and purpose of expropriation, describe the real or personal property sought to be expropriated, and join as defendants all persons owning or claiming to own or occupying any part thereof or interest therein, showing so far as practicable the separate interest of each defendant. If the title daw to any property sought to be expropriated appears to be in the Republic of the Philippines, although occupied by private individuals, or if the title is otherwise obscure or doubtful, so that the plaintiff cannot with accuracy or certainty specify who are the real owners, averment to that effect shall be made in the complaint. Ia-aver mo siya, ilalahad mo siya doon sa complaint. Section 2, entry of plaintiff upon depositing value with authorized government depository. Upon the filing of the complaint or at any time thereafter, and after due notice to the defendant, the plaintiff shall have the right to take or enter upon possession of the real property involved if he deposits with the authorized government depository to the assessed value of the property for purposes of taxation to be held by such bank, subject to the orders of the court. Such deposit shall be in money, unless in lieu thereof the court authorizes the deposit of a certificate of deposit of a government bank of the Republic of the Philippines payable on demand to the authorized government depository. If personal property is involved, its value shall be provisionally ascertained and the amount to be deposited shall be promptly fixed by the court. After such deposit is made by the court, ulitin natin. After such deposit is made, the court, dapat may kama kayo doon. The court shall order the sheriff or other proper officer to forthwith place the plaintiff in possession of the property involved and promptly submit a report thereof to the court with service of copies to the parties. Section 3. Defenses and objections. Kung daw ang isang defendant, if the defendant has no objection or defense to the action or the taking of his property, he may file and serve a notice of appearance and a manifestation to that effect, specifically designating or identifying the property in which he claims to be interested within the time stated in the summons. Yun daw ang depensa ron. Thereafter, he shall be entitled to notice of all proceedings affecting the same. Kapag daw, nag-file ng notice of appearance and manifestation at specifically dinesignate niya or in-identify niya yung property in which he claims to be interested within the time na sinabi doon sa summons, magiging entitled na raw siya na bigyan ng notice sa lahat ng proceedings na may kaugnayan doon. If a defendant does of his property, he shall serve his answer within the time stated in the summons. Parang naulit lang, no? The answer shall specifically designate or identify the property. In which he claims to have an interest, state the nature and extent of the interest claimed, and adduce o ilahad niya doon all his objections and defenses to the taking of his property. Paliwanag yan, bakit hindi nyo dapat kunin ang aking pag-aari? Wala raw counterclaim. No counterclaim, cross-claim, or third-party complaint shall be alleged or allowed in the answer or any subsequent pleading. Okay? Mahalaga yun, ha? No counterclaim, cross-claim, or third-party complaint shall be allowed in the answer or any subsequent susunod pang mga pleadings. A defendant waives all defenses and objections not so alleged, but the court, kunwari, ganun nga, winave ng defendant yung kanyang mga depensa, pero yung the court, yung korte, in the interest of justice, may permit amendments to the answer to be made not later than 10 days from the filing thereof. Yun nga lamang. However, at the trial of the issue of just compensation, whether or not a defendant has previously appeared or answered, he may present evidence as to the amount of the compensation to be paid for his property, and he may share in the distribution of the award. Of expropriation, ito na yung mabibigay ng order si korte ng expropriation na yan. If the objections to and the defenses against the right of the plaintiff to expropriate the property are overruled, or when no party appears to defend as required by this rule, the court may issue an order of expropriation declaring that the plaintiff has a lawful right to take the property sought to be expropriated for the public use or purpose described in the complaint upon the payment of just compensation to be determined as of the date of the taking of the property or the filing of the complaint, whichever came first. Usually, ang plaintiff dito yung gobyerno. Kukunin niya ang yung property for just compensation. Diba? O kaya yung mga contractor ng gobyerno na gagawa ng tulay, skyway, release ng tren, diba? Yan sa expropriation proceedings, sus Mariosep. Minsan hindi ka babayaran, sus Mariosep. The final order sustaining the right to expropriate the property may be appealed by any party aggrieved thereby. Such appeal, however, shall not prevent the court from determining the just compensation to be paid. After the rendition of such an order, the plaintiff shall not be permitted to dismiss or discontinue the proceeding except on such terms as the court deems just and equitable. Section 5. Ascertainment of compensation. Upon the rendition of the order of expropriation, the court shall appoint not more than 3 competent and disinterested persons as commissioners to ascertain, para masiguro, and report to the court the just compensation of the property sought to be taken. The order of appointment shall designate the time and place of the first session of the hearing to be held by the commissioners and specify the time within which their report shall be submitted to the court. Copies of the order shall be served on parties. Objections to the appointment of any of the commissioners shall be filed with the court within 10 days from service and shall be resolved within 30 days after all the commissioners shall have received copies of the objections. Section 6. Section 6. Proceedings by commissioners. Before entering daw upon the performance of their duties, itong mga commissioner na ito, di ba, discuss na natin previously na ina-appoint ng korte ito para mas mapabilis ang administrasyon ng hustisya. The commissioners shall take and subscribe an oath that they will faithfully perform their duties as commissioners, which oath shall be filed in court with the other proceedings in the case. Susumpa sila. Evidence may be introduced by either party before the commissioners who are authorized to administer oaths on hearings before them, and the commissioners shall, unless the parties consent to the contrary, after due notice to the parties, to attend, view, and examine. Ito mga partido na to shall attend, view, and examine the property sought to be expropriated and its surroundings, and may measure, susukat-sukatin nila the same, after which either party may by himself or counsel, magsama raw abogado o siya lang, argue the case. Yung mga commissioners daw shall assess the consequential damages to the property not taken and deduct from such consequential damages the consequential benefits to be derived by the owner from the public use or purpose of their property taken, the operation of its franchise with the corporation, or the carrying on of the business of the corporation or person taking the property. Yan ang magiging kapakinabangan ng person na yun doon. Kinuha mo yung lupa niya. Nagtayo ka kunwari ng Jollibee. Ano namang benepisyo niya ron, sus Mariosep? Pero yun ang nakalagay. But in no case shall the consequential benefits assessed exceed the consequential damages assessed. O tama naman, hindi naman matatawaran na mapapantay yung damage na yun yung ginawa. Or the owner be deprived of the actual value of his property so taken. So hindi mo raw pwedeng i-deprive. Yung actual na value niya, yun ang dapat mong bayaran. Nagtataka lang ako, bakit ang daming hindi nababayaran? Section 7. Report by commissioners and judgment thereupon. The court may order the commissioners to report when any particular portion of the real estate shall have been passed upon by them, and may render judgment upon such partial report and direct the commissioners to proceed with their work as to subsequent portions of the property sought to be expropriated, and may from time to time so deal with such property. Period. Haba, bago mag-period, no? The commissioners shall make a full and accurate report to the court of all their proceedings, and such proceedings shall not be effectual until the court shall have accepted their report and rendered judgment in accordance with their recommendations. Except as otherwise expressly ordered by the court, such report shall be filed within 60 days from the date the commissioners were notified of their appointment, which time may be extended in the discretion of the court. Upon the filing of such report, the clerk of court shall serve copies thereof on all interested parties with notice that they are allowed 10 days 10 days within which to file objections to the findings of the clerk's report. Upon the expiration of the period of 10 days referred to in the preceding section, or even before the expiration of such period, but after all the interested parties have filed their objections to the report of their statement of agreement therewith, the court may, after hearing, accept the report and render judgment in accordance therewith, or, for cause shown, it may recommit the same to the commissioners for further report or facts, or it may set aside the report and appoint new commissioners, or it may accept the report in part and reject it in part, and it may make such order or render such judgment as shall secure to the plaintiff the property essential therein as of right of expropriation, and to the defendant just compensation for the property taken. Section 9, uncertain ownership. Yung mga conflicting claims daw. If the ownership of the property taken is uncertain, or there are conflicting claims to any part thereof, the court may order any sum or sums awarded as compensation for the property to be paid to the court for the benefit of the person adjudged in the same proceeding to be entitled thereto. But the judgment shall require the payment of the sum or sums awarded to either defendant or the court before the plaintiff can enter upon the property or retain it for the public use or purpose if entry has already been made. Section 10. Karapatan ng plaintiff after judgment and payment. Upon payment by the plaintiff to the defendant of the compensation fixed by the judgment, with legal interest thereon from the taking of the possession of the property, or after tender to him the amount so fixed and payment of the costs, yung daw plaintiff ay may kakaroon ng karapatan to enter, right to enter upon the property expropriated and to appropriate it, for public use or purpose defined in the judgment, or to retain it should he have taken immediate possession thereof under the provisions of section 2 hereof. If the defendant and his counsel absent themselves from the court or decline to receive the amount tendered, the same shall be ordered to be deposited in court, and such deposit shall have the same effect as actual payment thereof to the defendant or the person ultimately adjudged entitled thereto. Section 11. Para nag-wrap na lang tayo dito. Okay, Section 11. Basahin na rin natin lahat. Sige. Section 11. Entry not delayed by appeal. Effect of reversal. Yun daw karapatan ng plaintiff to enter upon the property of the defendant and appropriate the same for public use or purpose shall not be delayed by any appeal from the judgment. But if the appellate court determines that the plaintiff has no right of expropriation, judgment shall be rendered ordering the regional trial court to forthwith enforce the restoration to the defendant of the possession of the property and to determine the damages which the defendant sustained and may recover by reason of the possession taken by the plaintiff. Section 12, costs. Sino nagbabayad ng cost? The fees of the commissioners shall be paid as a part of the cost of the proceedings. Ganun naman lagi. Basta may commissioner, part sila ng cost ng proceedings. All costs except those of rival claimants litigating their claims shall be paid by the plaintiff unless an appeal is taken by the owner of the property and the judgment is affirmed, in which event the costs of the appeal shall be paid by the owner. Section 13. Recording judgment and its effect. Yun daw judgment entered in expropriation proceedings shall state definitely by an adequate description the particular property or interest therein expropriated and the nature of the public use for purpose for which it is expropriated. When real estate is expropriated, a certified copy of such judgment shall be recorded in the registry of deeds of the place in which the property is situated, and its effect shall be to vest in the plaintiff the title to the real estate so described for such public use or purpose. Section 14. Power of guardian in such proceedings. The guardian or guardian ad litem of a minor or of a person judicially declared to be incompetent may, with the approval of the court first had, do and perform on behalf of his ward any act, matter, or thing respecting the expropriation for public use or purpose of property belonging to such minor or person judicially declared to be incompetent, which such minor or person judicially declared to be incompetent could do if such proceedings, in such proceedings, if he were of age or competent. So itong guardian na to, gagawin niya yung dapat na ginagawa ng minor na may-ari ng lupang subject to the expropriation proceedings kung sakaling siya ay nasa legal age. Yun lang ang gagawin ng guardian. Rule 68, foreclosure of real estate mortgage. Ay, iba naman to. Foreclosure. Mga sanlang tira tapos na foreclose. Ay. Section 1, complaint in action for foreclosure. In an action for the foreclosure of a mortgage or other encumbrance upon real estate, the complaint shall set forth the date and due execution of the mortgage, its assignments, if any, the names and residences of the mortgagor and the mortgagee, and a description of the mortgage property. Isasali na rin natin ang statement of the date of the note or other documentary evidence of the obligation secured by the mortgage at yung amount claimed to be unpaid thereon, and the names and residences of all the persons having or claiming an interest in the property subordinate in right to that of the holder of the mortgage, all of whom, lahat yan, shall be made defendants in the action. Section 2, judgment on foreclosure for payment or sale. If upon the trial in such action the court shall find the facts set forth in the complaint to be true, it shall ascertain the amount due to the plaintiff upon the mortgage debt or obligation, including interest and other charges as approved by the court and costs, and shall render judgment for the sum so found due, and order that the same be paid to the court or to the judgment obligee within a period of not less than 90 days, nor more than 120 days from the entry of judgment. Ulitin natin yon. Nor a period of not less than 90 days, nor more than 120 days from the entry of judgment. Doon, yung amount shall be paid. Utusan ng korte yung nangutang, that the amount shall be paid para masatisfy niya. And that in default, kung di siya nakabayad of such payment, the property shall be sold. Ibebenta po ito sa public auction para masatisfy mo yung hatol. So, ito ba yung ginawa dyan sa kapitbahay namin? Foreclosure of real estate. Nag-file sila ng complaint ng foreclosure, kaya nila nakuha yung bahay na yan, yung collateral sa kanila, tapos dinelay-delay yung bayad sa kanila. Section 3, sale of mortgage property. Effect. When the defendant, after being directed to do so as provided in the next preceding section, fails to pay the amount of the judgment within the period specified therein, the court, upon motion, shall order the property to be sold in the manner under the provisions of Rule 39 and other regulations governing sales of real estate under execution. Such sale shall not affect the rights of persons holding a prior encumbrances upon the property or a part thereof, and when confirmed by an order of the court. Also, upon motion, it shall operate to divest the rights in the property of all the parties to the action, and to vest their rights in the purchaser, subject to such rights of redemption as may be allowed by law. Upon the finality of the order of confirmation or upon the expiration of the period of redemption, pag-usapan natin yan, may 1-year period of redemption. When allowed by law, the purchaser at the auction sale or last redemptioner, napag-usapan na rin natin yan, kung meron mang last redemptioner, shall be entitled to the possession of the property unless a third party is actually holding the same adversely to the judgment obligor. The said purchaser or last redemptioner may secure a writ of possession upon motion from the court which ordered the foreclosure. Yun kung meron mang redemptioner o yung kunwari hindi siya kasali sa proceedings pero may interest siya dun sa lupa dahil may utang. Kunwari itong nagsanla, ang may pinag-usapan lang kasi dito nagsanla at pinagsanlaan. Yung nagsanla may utang din niya, third person siya. Siya ay redemptioner. Kung meron man, yan ang sinasabi rito. May bigyan siya ng instruction. Section 4, disposition of proceeds of sale. The amount realized from the foreclosure sale of the mortgage property shall, after deducting the cost of the sale, be paid to the person foreclosing the mortgage, and when there shall be any balance or residue after paying of the mortgage debt due, the same shall be paid to junior and their priority. Lahat ng mga may order of priority na bayaran yan. To be ascertained, ang magtatakda niyan yung court. Or if there be no such encumbrances, or there be a balance or residue after payment to them, then to the mortgagor or his duly authorized agent, or to the person entitled to it. Section 5. How sale to proceed in case the debt is not all due. O hindi pa raw due lahat ng utang. If debt for which the mortgage or encumbrance was held is not all due as provided in the judgment as soon as a sufficient portion of the property has been sold to pay the total amount and the costs due, the sale shall terminate. And afterwards, as often as more becomes due for personal or for principal or interests and other valid charges, the court may on motion order more to be sold. But if the property cannot be sold in portions without prejudice to the parties, the whole shall be ordered to be sold in the first instance, and the entire debt and costs shall be paid, if the proceeds of the sale be sufficient, therefore, there being a rebate of interest where such rebate is proper. Ano yung sinasabi sa Section 6? Deficiency judgment. If upon the sale of any real property as provided in the next preceding section, there be a balance due to the plaintiff after applying the proceeds of the sale, yun daw korte, the court, upon motion, shall render judgment against the defendant for any such balance for which, by the record of the case, he may be personally liable to the plaintiff, upon which execution may issue immediately if the balance is all due at the time of the rendition of the judgment. Otherwise, the plaintiff shall be entitled to execution at such time as the balance remaining becomes due under the terms of the original contract, which time shall be stated in the judgment. Section 7. Registration. A certified copy of the final order of the court confirming the sale shall be registered in the Registry of Deeds. If no right of redemption exists, the certificate of title in the name of the mortgagor shall be cancelled and a new one issued in the name of the purchaser. Sabi rito, where a right of redemption exists, the certificate of title in the name of the mortgagor shall not be cancelled, but the certificate of sale and the order confirming the sale shall be registered in a brief memorandum thereof, made by the Register of Deeds upon the certificate of title. In the event the property is redeemed, the deed of redemption shall be registered with the Registry of Deeds, and a brief memorandum thereof shall be made by the Registrar of Deeds on said certificate of title. If the property is not redeemed, the final deed of sale executed by the sheriff in favor of the purchaser at the foreclosure sale shall be registered with the Registry of Deeds, whereupon the certificate of title in the name of the mortgagor shall be cancelled and new one issued in the name of the purchaser. Section 8. Ang huling section ng Rule 68. Saan ba applicable itong mga provision na ito? The provisions of sections 31, 32, and 34 of Rule 39 shall be applicable to the judicial closure of real estate mortgages under this rule, insofar as the former are not inconsistent with or may serve to supplement the provisions of the latter. Punta na tayo sa Rule 69, Partition. Ako, ang haba pa nito. Sus Mariosep. Sayin natin. Let's read. Partition, Section 1. Complaint in action for partition of real estate. A person daw having the right to compel the partition of real estate, pagpaparte-partihin na yung real estate, may do so as provided in this rule, setting forth in his complaint the nature and extent of his title and an adequate description of the real estate of which partition is demanded, and joining as defendants all other persons interested in the property. Section 2. Order for partition and partition by agreement thereunder. Kung daw, if after the trial court finds that the plaintiff has the right thereto, it shall order the partition of the real estate among all the parties in interest. Thereupon, the parties may, if they are able to agree, make the partition among themselves by proper instruments of conveyance, and the court shall confirm the partition so agreed upon by all the parties, and such partition together with the order of the court confirming the same shall be recorded in the registry of deeds of the place in which the property is situated. A final order decreeing partition and accounting may be appealed by any party aggrieved thereby. Section 3. Commissioners to make partition when parties fail to agree. Kung daw yung mga partido ay hindi sila nakapag-kasundo, they are unable to agree upon the partition, the court shall appoint not more than 3. Laging 3, 3 competent and disinterested persons as commissioners to make the partition, commanding them to set off to the plaintiff and to each party in interest such part and proportion of the property as the court shall direct. Section 4. Oath and duties of commissioners. Before making such partition, the commissioners shall take and subscribe an oath that they will faithfully perform their duties as commissioners, which oath shall be filed in court with the other proceedings in the case. In making the partition, the commissioners shall view and examine the real estate after due notice to the parties to attend at such view and examination, and shall hear the parties as to their preference in the portion of the property to be set apart to them and the comparative value thereof, and shall set apart the same to the parties in lots or parcels as will be most advantageous and equitable, having due regard to the improvements, situation, and quality of the different parts thereof. Section 5. Assignment or sale of real estate by commissioners. When it is made to appear to the commissioners that the real estate or a portion thereof cannot be divided without prejudice to the interests of the parties, the court may order it assigned to one of the parties willing to take the same, provided he pays to the other party such amount as commissioners deem equitable, unless one of the interested parties asks that the property be sold instead of being so assigned, in which case the court shall order the commissioners to sell the real estate at public sale, auction na naman siya, under such conditions and within such time as the court may determine. Section 6. Report to commissioners. Proceedings not binding until confirmed. Ito mga commissioners na to shall make a full and accurate report to the court of all their proceedings as to the partition or the assignment of the real estate to one of the parties or the sale of the same. Upon the filing of such report, the clerk of court shall serve copies thereof on all interested parties with notice that they are allowed 10 days within which to file objections to the findings of the report if they so desire. No proceeding had before or conducted by the commissioners and rendered judgment thereon. Section 7. Action of the court upon commissioners' report. Upon the expiration of the period of 10 days referred to in the preceding section, or even before the expiration of such period, but after the interested parties have filed their objections to the report or their statement of agreement therewith, the court may, upon hearing, accept the report and render judgment in accordance therewith, or for cause shown, recommit the same to the commissioners for further report of facts. O naman daw, or set aside the report and appoint new commissioners, o pwede rin naman na accept the report in part and reject it in part, and may make such order and render such judgment as shall effectuate a fair and just partition of the real estate or of its value if assigned or sold as above, provided between the several owners thereof. Section 8, accounting for rent and profits in action for partition. In an action for partition, in accordance with this rule, a party shall recover from another his just share of rents and profits received by such other party from the real estate in question, and the judgment shall include an allowance for such rents and profits. Section 9, ano naman daw kapangyarihan na naman ng guardian? Yung guardian na naman daw ay may kapangyarihan na gawin yung dapat gagawin nung minor kung yung minor ay hindi minor. Okay. Section 10. Costs and expenses to be taxed and collected. The court shall equitably tax and apportion between or among the parties the costs and expenses which accrue in the action. Kasama na raw dyan yung mga compensation ng commissioners having regard to the interests of the parties, and the execution may issue therefore as in other cases. Ano naman yung epekto ng judgment? Copy to be recorded in Registry of Deeds. Sa actual partition daw ng property, yung judgment shall state definitely by metes and bounds and adequate description the particular doon kung ano ba yung na-assign sa akin, sa Joseph. Kung ang buong property daw is assigned to one of the upon his paying to the others, nagbayad siya ng sum na in order ng court, yung judgment daw shall state the fact of such payment and of the assignment of the real estate to the party making the payment, and the effect of the judgment shall be to vest in the party making the payment the whole of the real estate free from any interest on the part of the other parties to the action. If the property is sold and the sale confirmed by the court, the judgment thou shall state the name of the purchaser or purchasers and a definite description of the parcels of real estate sold sa bawat purchaser. At yung epekto of the judgment shall be to vest the real estate in the purchaser or purchasers making the payment or payments free from any claims or payments free from claims of any of the parties to the action. A certified copy of the judgment shall in either case be recorded in the Registry of Deeds of the place in which the real estate is situated, and the expenses of such recording shall be taxed, bubuwisan, bilang bahagi ng costs ng action. Ito naman tayo rito. Section 12, neither paramount rights nor amicable partition affected by this rule. Sige, hindi raw maapektuhan yung mga anong tawag dito, yung mga nag-amicable settlement. Hindi siya maapektuhan ng rule na ito. Section 13, partition ng personal property. The provisions of this rule shall apply to partitions of estates composed of personal property or of both real and personal property insofar as the same may be applicable. Hapit na ba? So, mahaba pa. Sige, anahin na natin. Basahin na natin lahat. Ang haba pa ng 70 to 71. Isang rule, napakahaba. Sus Maria Joseph. Ito. Ito naman yung Rule 70 naman yung tungkol sa forcible entry and unlawful detainer. Sa pagkakaalam ko po, ito ay krimen na ipina-file sa MTC. Section 1. Who may institute proceedings and when? Subject to the provisions of the next succeeding section, a person deprived of the possession, person deprived of the possession of any land or building by force, intimidation, threat, strategy, or stealth, or a lessor, vendor, vendee, or other person against whom the possession of any land or building is unlawfully withheld after the expiration or termination of the right to hold possession by virtue of any contract, express man yan o implied, or the legal representative or assigns of any such lessor, vendor, vendee, or other person may at any time within 1 year after such unlawful deprivation or withholding of possession bring the action. 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 Bring the in the proper MTC, Municipal Trial Court, against the persons or persons unlawfully withholding or depriving possession or any person or persons claiming under them for the restitution of such possessions together with damages and costs. Lessor to proceed against lessee only after demand. Yun daw, basahin lang natin. Unless otherwise stipulated, such action by the lessor shall be commenced only after demand to pay or comply with the conditions of the lease and to vacate is made upon the lessee, or by serving written notice of such demand upon the person found in the premises, if no person be found thereon and the lessee fails to comply therewith, after 15 days in the case of land or 5 days in the case of buildings. So yung lessor, pwede niya lamang kasuhan nito yung lessee, yung nangungupahan sa kanya, only kapag nag-demand na siya na mag-vacate ka. Tapos ayaw mo pa rin mag-vacate. Section 3, Summary Procedure. Except thou in cases covered by the agricultural tenancy laws or when the law otherwise expressly provides, lahat daw ng actions or forcible entry and unlawful detainer, irrespective of the amount of damages or unpaid rentals sought to be recovered, shall be governed by the summary procedure hereunder provided. So, ito, sinasabi naman dito yung mga pleadings na allowed. Meron yata tayong rule on summary procedure nga. Mamaya na. Babasahin din natin sa ibang pagkakataon. Civil procedure muna tayo. Ito yung mga pleading na pinapayagan para sa unlawful detainer cases. The only pleadings allowed to be filed are complaint, compulsory counterclaim, and cross-claim pleaded in the answer and the answers thereto. Lahat doon ng pleadings shall be verified. Ibig sabihin, may certification of non-forum shopping. Yun nga ba yun? Kung hindi po yun, please comment down below. Section 5, Action on Complaint. The court may, from an examination of the allegations in the complaint and such evidence as may be attached thereto, dismiss the case outright on any of the grounds for the dismissal of a civil action which are apparent therein. If no ground for dismissal is found, it shall forthwith issue summons. Answers, Section 6. Within 10 days daw from service of summons, tanggap mo yung summon ngayon, bibilang ka ng 10 days, yun daw defendant shall file his answer to the complaint and serve a copy thereof on the plaintiff. Affirmative and negative defenses not pleaded therein shall be deemed waived, except for lack of jurisdiction over the subject matter. Cross-claims and compulsory counterclaims not asserted in the answer shall be considered barred. Hindi na pwede. The answer to counterclaims or cross-claims shall be served and filed within 10 days from service of the answer in which they are pleaded. Section 7. Ano yung epekto ng failure to answer? Should the defendant fail to answer the complaint within the period above provided, the court motu proprio or on motion of the plaintiff shall render judgment as may be warranted by the facts alleged in the complaint and limited to what is prayed for therein. The court may, in its discretion, reduce the amount of damages and attorney's fees claimed for being excessive or otherwise unconscionable without prejudice to the applicability of Section 3, Rule 9 if there are 2 or more defendants. Section 8, Preliminary Conference, Appearance ng mga parties. Sabi rito, not later than 30 days, 30, after the last answer is filed, a preliminary conference daw shall be held. Parang ganun din sa diniscuss natin previously. Nag-file na kayo ng inyong pleading, magkakaroon ng preliminary conference. The provisions of Rule 18, yung nabasa natin dati, on pre-trial shall be applicable on the preliminary conference unless inconsistent with the provisions of this rule. The failure daw of the plaintiff to appear in the preliminary conference shall be cause for the dismissal of his complaint. The defendant who appears in the absence of the plaintiff shall be entitled to judgment on his counterclaim. Yung counterclaim niya, in accordance with the next preceding section, all cross claims shall be dismissed. If a sole defendant shall fail to appear, the plaintiff shall likewise be entitled to judgment in accordance with the next preceding section. The procedure shall not apply where one or two or more defendants sued under a common cause of action. Defense shall appear at the preliminary conference. Wala rin daw postponement. No postponement of the preliminary conference shall be granted except for highly meritorious grounds and without prejudice to such sanctions as the court, in the exercise of sound discretion, may impose on the movant. Section 9. Record of preliminary conference. Within 5 days daw after the termination of the preliminary conference, the court shall issue an order stating the matters taken up therein. Kumbaga pinagsasama-sama tayo. Ano ba yung mga dapat nating talakayin dito? Number 1, whether the parties have arrived at an amicable settlement, and if so, ano yung mga terms nito? Number 2, stipulations or admissions entered into by the parties. Number 3, whether on the basis of the pleadings and the stipulations and admissions made by the parties, judgment may be rendered without the need of further proceedings, in which event the judgment shall be rendered within 30 days from issuance of the order. Number 4, a clear specification of material facts which remain converted. And number 5, such other matters intended to expedite o para pabalisin ang disposition of the case. Section 10, submission of affidavits and position papers. Within 10 days daw from receipt of the order mentioned in the next preceding section, the parties shall submit the affidavits of their witnesses and other evidence on the factual issues defined in the order, together with their position papers, setting forth the law and the facts relied upon by them. Section 11, period of rendition of judgment. Within 30 days after receipt of the affidavits and position papers or the expiration of the period for filing the same, yun daw korte shall render judgment. However, should the court find it necessary to clarify o lilinawin niya yung mga certain material facts during the said period, pwede siyang mag-issue ng order specifying the matters to be clarified, and i-require niya yung mga partidos to submit affidavits or other evidences on the said matters sa loob or within 10 days from receipt of said order. Judgment shall be rendered within 15 days after the receipt of the last affidavit or the expiration of the period for filing the same. The court shall not resort to the foregoing procedure just to gain time for the rendition of judgment. Section 12. Referral for conciliation. Cases requiring referral for conciliation where there is no showing of compliance with such requirement shall be dismissed without prejudice and may be revived only after that requirement shall have been complied with. Yung mga kaso raw na kinakailangan ng conciliation, kailangan dumaan ka muna doon. Okay? Section 13. Prohibited pleadings and motions. Ano yung mga ipinagbabawal na petition, motion, or pleadings? Ano yung mga bawal? Ano yung mga not allowed? Number 1, motion to dismiss the complaint except on the ground of lack of jurisdiction over the subject matter or failure to comply with Section 12. Ano yung ikalawa? Motion for bill of particulars. Bawal yan dito. Number 3, motion for new trial or for reconsideration of a judgment or for reopening of trial. Bawal din yan. Number 4, petition for relief from judgment. Bawal yan. Number 5, motion for extension of time to file pleadings, affidavits, or any other paper. Number 6, memoranda. Bawal yan. Number 7, petition for certiorari, mandamus, or prohibition against any interlocutory order issued by the court. Number 8, motion to declare the defendant in default. Bawal din yan. Number 9, dilatory motions for postponement. Number 10, reply. Ang gusto niya lang dito yung nag-file ka ng complaint, sumagot siya. Huwag ka na mag-reply. 11, third-party complaints. Bawal. At interventions. Bawal din to. So, nilinaw niya yung mga bawal. Sa madaling salita, mas simple itong pagkakaso na ito. Section 14, affidavits. The affidavits required to be submitted under this rule shall state only facts of direct personal knowledge of the affiants which are admissible in evidence and shall show their competence to testify to the matter stated therein. A violation of this requirement may subject the party or the counsel who submits the same to disciplinary action and shall be caused to expunge the inadmissible affidavit or portion thereof from record. Tatanggalin yon sa record. Kasi inadmissible yung ebidensya mo eh. Section 15. Preliminary Injunction. The court may grant preliminary injunction in accordance with the provisions of Rule 58 hereof to prevent the defendant from committing further acts of dispossession against the plaintiff. So yung nabanggit natin kanina, preliminary injunction. Pwede raw yung plaintiff present a motion in the action for forcible entry or unlawful detainer for the issuance of a writ of preliminary mandatory injunction to restore him in his possession. The court shall decide the motion within 30 days from the filing thereof. So, pwede palang humiling yung plaintiff ng writ of preliminary mandatory injunction. Okay? Pwede siyang humingi ng writ of preliminary injunction. Hindi siya nakalagay sa mga ipinagbabawal na motion. Okay? Writ of preliminary injunction. Section 16, resolving defense of ownership. Okay, resolving the defense of ownership. Wait lang, sandali lang. Yes. Yeah. Kain ka na. Okay. Tuloy tayo. Section 16. Resolving defense of ownership. When the defendant raises the defense of ownership in his pleadings and the question of possession cannot be resolved without deciding the issue of ownership, the issue of ownership shall be resolved only to determine the issue of possession. Section 17, judgment. Ito na. If after trial court finds that the allegations of the complaint are true, it shall render judgment in favor of the plaintiff for the restitution of the premises, the sum justly due as arrears of rent or as reasonable compensation for the use and occupation of the premises, attorney's fees, and costs. If a counterclaim is established, the court shall render judgment for the sum found in arrears from either party and award costs as justice requires. Section 18, judgment conclusive only on possession. Not conclusive in actions involving title or ownership. Yun ang topic ng Section 18. The judgment rendered in an action for forcible entry or detainer shall be conclusive with respect to the possession only, and shall in no wise, ayun ba yung salita doon? And shall in no wise, o basta, it shall not bind the title or affect the ownership of the land or the building. Ang pinag-uusapan, conclusive lamang daw ito sa possession. Hindi ito issue ng ownership. Such judgments shall not bar an action between the same parties respecting the title to the land or building. So kung sinabi, dalawa tayo, sinabi, ako yung may possession ng building na ito, ako yung kinatigan ng korte, hindi naman ibig sabihin nun, hindi na ikaw pwede magsampa ng kaso kung sa tingin mo ay ikaw ang tunay na may-ari nung property. Pwede ka mag-file ng kaso. Ibang kaso. The judgment or final order shall be appealable to the appropriate RTC, Regional Trial Court, which shall decide the same on the basis of the entire record of the proceedings had in the court of origin and such memoranda and briefs as may be submitted by the parties or required by the RTC. Ito naman, immediate execution daw ng judgment. Paano daw ipapastay? If judgment is rendered against the defendant, execution shall issue immediately upon motion unless an appeal has been perfected and the defendant to stay execution files a sufficient supersedeas bond na inaprubahan ng municipal trial court and executed in favor of the plaintiff to pay the rents, damages, and costs accruing down to the time of the judgment appealed from, and unless during the pendency of the appeal, he deposits with the appellate court the amount of rent due from time to time under the contract, kung meron man, if any, as determined by the judgment of the municipal trial court. Period. Haba ng period. In the absence of a contract, he shall deposit with the regional trial court the reasonable value of the use and occupation of the premises for the preceding month or period at the rate determined by the judgment of the lower court on or before the 10th day of each succeeding month or period. The supersedeas bond shall be transmitted by the municipal trial court with the papers to the clerk of the regional trial court to which the action is appealed. Lahat daw ng amounts to be so paid to the appellate court shall be deposited with said court or authorized government depository bank and shall be held there until the final disposition of the appeal unless the court by agreement of the interested parties or in absence of reasonable grounds of opposition to a motion to withdraw or for justifiable reasons shall decree otherwise. Should the defendant fail to make the payments above prescribed from time to time during the pendency of the appeal, the appellate court, upon motion of the plaintiff and upon proof of such failure, shall order the execution of the judgment appealed from with respect to the restoration of possession, but such execution shall not be a bar to the application thereof on the merits. After the case is decided by the regional trial court, any money paid to the court by the defendant for purposes of the stay of execution shall be disposed of in accordance with the provisions of the judgment of the regional trial court. In any case wherein it appears that the defendant has been deprived of the lawful possession of land or building pending the appeal by virtue of the execution of the judgment of the municipal trial court, damages for such deprivation of possession and restoration of possession and restoration, paulit-ulit yan deprivation and restoration of possession may be allowed the defendant in the judgment of the regional trial court disposing the appeal. Section 20, Preliminary Mandatory Injunction in case of appeal. Upon motion daw ng plaintiff, within 10 days from the perfection of the appeal to the regional trial court, the latter may issue a writ of preliminary mandatory injunction to restore the plaintiff in possession if the court is satisfied na yung apila that the defendant's appeal is frivolous or dilatory or that the appeal of the plaintiff is prima facie meritorious. Section 21, Immediate execution on appeal to Court of Appeals or Supreme Court. The judgment of the regional trial court against the defendant shall be immediately executory without prejudice to a further appeal that may be taken therefrom. Okay? Immediately executory na pag MTC yung pinag-uusapan natin kaso forcible entry and lawful attainder, umapila ka sa RTC, yung decision nila shall be immediately executory. Yun nga lang, pwede ka pa rin umapila sa taas. Magtungo na tayo sa Rule 71. O, tapusin na natin to. Madami pa to, pero tapusin na natin. The final rule ng civil procedure, contempt. Kanina pa natin nababanggit yung contempt. Section 1, direct contempt punished summarily. Ayan, kasi nga may summary proceedings eh. Ang isang person daw na guilty of misbehavior in the presence of or so near a court as to obstruct or interrupt the proceedings before the same, including disrespect toward the court, offensive personalities toward others, or refusal to be sworn, ayaw mong manumpa as a witness, or to subscribe an affidavit or deposition when lawfully required to do so, may be summarily adjudged in contempt by such court and punished by a fine not exceeding 2,000 pesos or imprisonment not exceeding 10 days or both if it be a regional trial court or a court of equivalent or higher rank, or by a fine not exceeding 200 pesos or imprisonment not exceeding 1 day or both if it be a lower court. Section 2, ano yung remedyo mo? The person adjudged in direct contempt by any court may not appeal therefrom, but may avail himself of the remedies of certiorari or prohibition. The execution of the judgment shall be suspended pending resolution of such petition, provided such person files a bond fixed by the court which rendered the judgment and conditioned that he will abide by and perform the judgment should the petition be decided against him. Wala ka ng remedyo, apila ka na lang. Remedy mo is certiorari or prohibition. Pero magfa-file ka ng bond sa korte at mangangako na ka na kung sakaling matalo ka sa apila mo, susundin mo yung judgment laban sa iyo. May kulong po ito, 10 araw daw. Section 3, Indirect Contempt. O ano naman itong Indirect Contempt? After a charge in writing has been filed and an opportunity given to the respondent to comment thereon within such period as may be fixed by the court and to be heard by himself or counsel, a person guilty of any of the following acts may be punished for direct contempt. O, ito yun. A. Pwede siyang mapasahan ng indirect contempt. A. Misbehavior of an officer of a court in the performance of his officials or in his official transactions. B. Disobedience of or resistance to a lawful writ, process, order, or judgment court, including the act of a person who, after being dispossessed or rejected from any real property by the judgment or process of any court of competent jurisdiction, enters or attempts or induces another to enter into or upon such real property for the purpose of executing acts of ownership or possession, or in any manner disturbs the possession given to the person adjudged to be entitled thereto. Yung nanalo sa kaso na siya yung dapat na entitled doon, ginulo mo. Letter C, any abuse of or any unlawful interference with the processes or proceedings of a court not constituting direct contempt under Section 1. So basta hindi siya direct contempt pero nang ginugulo mo yung court, indirect contempt to. Letter D, any improper conduct tending directly or indirectly to impede, obstruct, or degrade the administration of justice. Letter E, assuming to be an attorney or an officer of a court and acting as such without authority. So, kunwari, nagpapanggap ka na abogado ka, hindi naman. O nagpapanggap ka na ikaw ay taga-korte, hindi naman. Letter F, failure to obey a subpoena duly served. Pinatawag ka ng korte, hindi ka nagpunta. Letter G, the rescue or attempted rescue of a person or property in the custody of an officer by virtue of an order or process of a court held by him. Nasa pangangalaga is ang gamit na ito. Itong taong ito ang isang gamit tapos pinilit mong kunin. That is indirect contempt. But nothing in this section shall be construed o hindi raw ito iisipin na as to prevent the court from issuing processes to bring the respondent into court or from holding him in custody pending such proceedings. Paano naman daw sinisimulan Proceedings for indirect contempt may be initiated motu proprio by the court against which the contempt was committed by an order or any other formal charge requiring the respondent to show cause why he should not be punished for contempt. In all other cases though, charges for indirect contempt shall be commenced by a verified petition with supporting particulars and certified true copies of documents or papers involved therein, and upon full compliance with the requirements for filing initiatory pleadings for citizens in the court concerned. If the contempt charges arose out of or are related to a principal action pending in the court, the petition for contempt shall allege that fact, but said petition shall be docketed, heard, and decided separately unless the court in its discretion orders the consolidation of the contempt charge and the principal for joint hearing and decision. Saan daw ito fina-file? Where the charge for indirect contempt has been committed against a regional trial court or a court of equivalent or higher rank or against an officer appointed by it, the charge may be filed with such court. Patay ka, doon din siya charge. Where such contempt has been committed against a lower court, the charge may be filed with the regional trial court of the place in which the lower court is sitting. But the proceedings may also be instituted in such lower court subject to appeal to the regional trial court of such place in the same manner as provided in Section 11 of this rule. Section 6. Hearing at yung release on bail. If the hearing is not ordered to be had forthwith, the respondent may be released from custody upon filing a bond in an amount fixed by the court for his appearance at the hearing of the charge. On the day set, therefore, the court shall proceed to investigate the charge and consider such comment, testimony, or defense as the respondent may make or offer. Section 7. Punishment for indirect contempt. If the respondent is adjudged na hatulan siyang guilty of indirect contempt committed against a regional trial court or a court of equivalent or higher rank, he may be punished by a fine not exceeding 30,000 pesos or imprisonment not exceeding 6 months. Sus Maria Jose, matagal-tagal din. Or both. If he is adjudged guilty of contempt commitment not exceeding 1 month or both, bahid ka na ng 5,000, kulong ka pa ng 1 month. If the contempt consists in the violation of a writ of injunction, temporary restraining order, or status quo order, he may also be ordered to make complete restitution to the party injured by such violation of the property involved or such amount as may be alleged and proved. The writ of execution, as in ordinary civil actions, shall issue for the enforcement of a judgment imposing a fine unless the court otherwise provides. Lapit na tayo, Section 8. Imprisonment until order obeyed. When contempt consists in the refusal or omission to do an act which is yet in the power of the respondent to perform, he may be imprisoned by order of the court concerned until he performs it. I-perform mo na agad. Section 9. Proceeding when party released on bail failed to answers. Kapag the respondent pinakawalan dahil sa piyansa, hindi siya nag-appear sa hearing, the court may issue another order of arrest or may order the bond for his appearance to be forfeited. Kukunin na, hindi mo na mababawi yung bond mo, yung piyansa mo. And if the bond be proceeded against, the measure of damages shall be the extent of the loss or injury sustained by the aggrieved party by reason of the misconduct for which the contempt was prosecuted, with the costs of the proceedings, and such recovery shall be for the benefit of the party injured. If there is no aggrieved party, the bond shall be liable and disposed of as in criminal cases. Konti na lang. Konti na lang. Section 10. Court may release respondent. The court which issued the order imprisoning a person for contempt may discharge him from imprisonment when it appears that public interest will not be prejudiced by his release. Section 11. Review of judgment or final order. Bond for stay. The judgment or final order of a court in case of indirect contempt may be appealed to the proper court as in criminal cases. But execution of the judgment or final order shall not be suspended until a bond is filed by the person na nahatulan or adjudged in contempt in an amount fixed by the court from which the appeal is taken, conditioned that if the appeal be decided against him, he will abide by and perform the judgment or final order. Banggit na natin kanina yan. Section 12, contempt against quasi-judicial entities. So, pwede rin pala. Unless otherwise provided by law, this rule shall apply to contempt committed against persons, entities, bodies, or agencies exercising quasi-judicial functions or shall have suppletory effect to such rules as they may have adopted pursuant to authority granted to them by law to punish contempt. Di ba may contempt rin kapag hindi ka sumunod sa mga hearing sa mga quasi-judicial agencies, kunwari COA o COMELEC, pwede ka nila i-contempt o nanggugulo ka doon. The regional trial court of the place wherein the contempt has been committed shall have jurisdiction over such charges as may be filed therefore. So dyan po nagtatapos ang Rule 61 to 71. Dyan nagtatapos ang kabuuan ng civil procedure. Ako po'y magbabalik para sa isa na mga edisyon ng aking pagbabasa ng mga pagkahirap-hirap unawain ng mga batas at subukan natin siyang ipaliwanag in layman's terms. Goodbye and good night.